We are fortunate to have our very own Mr. Babatunde Irukera, up until quite recently, partner in the law firm of Simon Coopers and also chair of the SBL Consumer Protection and Competition Committee. Tunde was recently appointed Director General of the Consumer Protection Council by the government of President Muhammadu Buhari. Tunde is here with us, and he's going to speak to us on issues in that space. Essentially, we want to hear from him what exactly is going on with the issues of competition. The competition bill that has remained a bill since I was a kid. I'm joking, of course. But we know that it's taking forever. We know that we have weak governance issues or weak regulatory framework with regard to consumer protection issues. And Tunde has assured me that things are definitely going to change now that there's an SBL man in place. Join me in bidding welcome our friend, our brother, Babatunde Irukera, Director General, Consumer Protection, and if I might mention, tall, handsome, dapper gentleman. Thank you.
Good afternoon. And I thought it was going to be very nice to be here. It was pretty attractive when it was going to be a lunch hour conversation. The reason is because I know that a keynote speech is unlikely to distract from the food. But now that the lunch happened first, you're going to have to accept that if you do not like what I am saying, it's because they changed the plan. But if what I say makes any sense, it's because I'm that smart. When I first spoke with Olumide, he said he'd like me to talk primarily about the regulatory space and what the potential new law, that is the proposed Federal Competition and Consumer Protection Bill or Act, would do, and how that could change the face of legal practice, and how that could provide new opportunities for lawyers, especially business lawyers. And so I started thinking, and what kept coming back to my mind is a typical cliche that the whole of society uses. That's follow the law. And so I said, if you think about follow the law, and the fact that our theme this year is law and the changing face of legal practice, then who's really following? And how much following are we really doing? And if we agree that law is the framework of societal existence, or at least the tracks that society runs on as a train, then we must ask the question that if society would follow the law, what does the law follow? And I say the law follows lawyers, because it doesn't matter what the composition of any parliament is, lawyers actually are very instrumental in crafting laws. And that's what our role as lawyers should be. We should adopt a regulatory practice that actually reflects what society is like. And so, with respect to whether law can change the face of legal practice, I propose that lawyers should be both that face and the pace at which it changes. And you might say that if we would be the face and the pace, then how come we run into the perennial trouble we run into, especially with the National Assembly and how quickly laws are passed? Well, the model that has succeeded in many parts of the world has never been a parliament that works very quickly. It has never been a parliament that's very sensitive to what industry proposes or likes. The model that has always worked all over the world has been the model of lawyers being innovative and learning to improvise. And so permit me for a moment when I say that I don't think the National Assembly is the biggest piece of how we can change the face of legal practice or how the law can be relevant in society. And the reason is very clear, because we interpret law and the National Assembly simply makes law. And the reason why the National Assembly has a continuing role with respect to law is that after they've written anything and then after signature it becomes characterized as law, we interpret it. And it's that interpretation that makes them seek to amend it. Because many times they say, well, the interpretation that we lawyers have adopted has created a mischief. And so for me, with or without a competition legislation, consumer protection already captures competition. But that said, what real opportunities, what does this bill propose? Essentially, what the bill does is to take the existing provisions in the Consumer Protection Act, expands them a little, it takes away some of the powers, but it also adds to it a completely new dimension, and that is a competition regime. For as long as I've known competition law to operate in the world, I've heard a popular saying that the only worst thing than a government monopoly is a private monopoly. And that's what we've had. And so when, as a country, government decided to get out of commerce and sell the companies that were previously government owned, going down that road without a comprehensive competition legislation was obviously a risk. And some of the results of that risk is what we are seeing now. However, that said, for over a decade, we have tried to pass competition law in Nigeria. But the 8th National Assembly has succeeded. Much earlier this year, the House of Representatives passed a federal competition and consumer protection bill. About 2 weeks ago, the Senate also passed a federal competition and consumer protection bill, albeit materially different from what the House passed. I understand that both chambers will go into conference in the coming weeks and perhaps come to some kind of understanding where they have a final bill that will go to the executive for assent. Now, what does this mean for us as business lawyers? I've always thought that competition and consumer protection are the most vital instruments that a government uses to regulate the marketplace. And for as long as that is the case, then we as business lawyers must understand what that space is. I think the quality of regulatory practice in Nigeria is still relatively low. And regulators many times are as far behind as even we, the lawyers. But the regulators are never going to get ahead. It is private bar that always drives innovation and growth. And so what we must do as lawyers is to start thinking through what the real theories of liability, the different theories of liability that exist for consumer violations and certainly for anti-competitive behavior. I think competition law is the one space that provides as many opportunities for lawyers than any other. And the reason is this: you would have a one lawyer firm that can represent a one-man business against a large corporation. And so the big firm or the more resourced firm represents a large corporation, but a single lawyer who has the right of private antitrust action would represent the small business. Primarily, competition is a business-to-business relationship, but the real impact is a marketplace impact. And so, look at the different parties who could be involved in a potential competition dispute. You've got two businesses that could go up against each other, or a consumer that could go up against a business, a trade association, or a whole industry. And so because of that, if we're able to analyze that well, then we would see what the opportunities are. But in seeing those opportunities, we must be concerned also about how we as lawyers would look in the mirror the morning after. And when I say the morning after, I mean the next day after we have competition legislation. And just a quick poser that I'd like us to think about. We as lawyers have a scale of fees, isn't that correct? And so if we had competition legislation that regulates both the industry and trade associations or professional associations, our scale of fees, would that become collusion or would it become anti-competitive? And so those are the questions we must ask ourselves. And those are the first things we must do as lawyers. First, to analyze what the space is and get with the program to the point where we've interrogated the issues sufficiently within our own association before even trying to address what is out there. Commerce as we know it now is global and dynamic, and legal practice must actually lead. If we cannot lead in legal practice, we must at least be at par with the development of business and commerce globally. And so beyond being a framework, law is perceived as a solution these days. And so the lawyer is no longer a referee with a whistle, and I don't mean for whistle blowing, I mean for regulating the space. The lawyer is seen as a team player. And so what do we do now as lawyers? Do we sit around in a business meeting with a red card or yellow cards and say, well, the framework would not permit that? Or do we arrive ready to play on a team of how to make things really happen? Business people who have gotten to a point where they do not recognize or tolerate our attitude to how business operates. They just want to do business. And so what we must do as lawyers is understand that. Under the new law, there would be a competition tribunal, a competition and consumer protection tribunal. I'm hopeful that that tribunal will not get bogged down like the courts have become with dry issues like interpretation of Order 5, Rule 6, or the difference between a concurrent writ and a current writ. If that be the case, then I know that we would be in a better position. But finally, what I'd like to say is that to the extent that our role as lawyers is to protect society, we must see the opportunity in every violation of consumer rights as a potential legal opportunity. And instead of perhaps going straight to court, consider the regulatory space and consider what the tools are in the regulations for addressing some of these violations. I want to thank you very much, and I hope that I'd see a lot of you sooner than later on the other side. Thank you.